weirdest stuff I saw. It's been
There's other things that I don't remember.
I remember a guy that the apartment building this time. You walk in the front door of the building. Here's our apartment. Walk in the front door, go on our park door there, maybe a couple more down, stairs straight up. And he was, I guess he was carrying groceries down or something. He fell down 4 steps.
I think we're about good to get started. Well, good afternoon. Welcome to the National Press Club, the place where news happens. I'm Emily Wilkins, treasurer of the National Press Club and the congressional reporter for Bloomberg Government. Thank you so much for joining our headliners event with West Virginia Attorney General Patrick Morrisey and Indiana Attorney General Todd Rokita. Thank you both so much for being here with us today. We are happy to accept your questions. This is the Press Club after all, and we will ask as many as we can as time permits. If you are with us here today, welcome. Cards are going to be passed around. You can fill out your questions on those and hand them to Kate, who is walking around the back. And if you are watching online, please submit your questions to headliners, headliners, @press.org. That's .org, not .com. And please put SCOTUS in the subject line. The Supreme Court on February 28th will hear oral arguments in West Virginia versus EPA. This short, simple title belies the wide-ranging legal complexity of a case that stems from the Trump administration's decision to repeal the Obama administration's 2015 Clean Power Plan. Vox Supreme Court reporter Ian Millhiser called West Virginia versus EPA a, quote, monster of a case that could drastically shrink the power of federal agencies to set rules on everything from pollution controls to workplace safety. Case Western Reserve University law professor Jonathan H. Adler said the case could become, quote, one of the most significant environmental law cases of all time. The story of this case begins with the Clean Power Plan, a 2015 Obama-era regulation which would have forced utilities to phase out coal and move toward renewable energy in an effort to reduce carbon emissions. The Trump administration repealed that plan and replaced it with its Affordable Clean Energy Rule, which relaxed the rules for carbon emissions. On January 19th of 2021, the final day of Trump's presidency, the DC Appeals Court struck down the Affordable Clean Energy Rule. West Virginia, the attorneys general from 17 other states, the governor of Mississippi, and several coal companies have petitioned the Supreme Court to overturn the appeals court decision, arguing that the EPA has overstepped its power by using the Clean Air Act to regulate CO2 emissions from power plants. The EPA contends that Congress did grant them that power, and we will be hearing more on that today, as well as those Supreme Court arguments. But here to explain the Attorneys General challenge to the Clean Air Act is West Virginia Attorney General Patrick Morrisey, Indiana Attorney General Todd Rokita. Attorney General Morrisey, now in his third term, has practiced law since 1992 with a primary focus on healthcare issues. He knows his way around Washington too, having served as Deputy Staff Director and Chief Healthcare Counsel to the House Energy and Commerce Committee. And Attorney General Rokita was elected in 2020, and he previously served 4 terms as a member of the House of Representatives from Indiana's 4th Congressional District and served 2 terms as Secretary of State for Indiana. We're going to start off by hearing remarks from both of these gentlemen, and then we're going to be moving on to a question and answer. And once again, if you have any questions, we'll be happy to take as many as we can as time permits. But Attorney General Morrisey, the floor is yours.
Well, thank you so much, Emily, and thank you to everyone who joined us today. This is really an exciting time to be focusing on the U.S. Supreme Court because I think we have a real treat for you today. We're going to be talking about one of the most important administrative law and separation of powers cases that has come around in quite some time, and we're really looking forward to getting into the details of this. I want to start out, first of all, by thanking my colleague, Attorney General Todd Rokita, for coming in from Indiana today. Todd has been part of a group of attorneys general who's really been steadfast going after federal overreach, and I think his background fits perfectly into the attorneys general position because of experience in state government as Secretary of State and also as a member of Congress. So I think you're going to hear some very unique perspectives about Congress's role in non-delegation from him today. I'd also like to ask for a moment of silence first for someone who just recently passed away. My good friend, the Attorney General from North Dakota, couldn't be here today. We had talked about doing this event. He's been a friend and a partner on many issues and he passed away recently at the age of 68, so I just take a moment to honor his memory, Wayne Stengham. All right, well, you're probably hearing a lot from different people about what some folks believe this case should be about. Ostensibly, many people are talking about it as the huge climate change case. I'd like to think about it a little bit differently. I think this is really about a fundamental question of who decides the major issues of the day. Should it be unelected bureaucrats, or should it be the people's representatives in Congress? That's what this case is all about. It's very straightforward. You're going to hear from a lot of people who are going to try to look for dragons in the side of the briefs, and oh my goodness, the attorneys general are trying to stop this climate change effort. Nothing could be further from the case. What we're looking to do is to make sure that the right people under our constitutional system make the correct decisions. These agencies, these federal agencies, don't have the ability to act solely on their own without getting a clear statement from Congress. Delegation matters. It matters for purpose of ensuring that Congress is fulfilling its role under the Constitution, and the states have the ability to join their role in a cooperative federalism system as well. We've been pushing this concept for quite some time, and as many of you know, we've been down this pathway before at the U.S. Supreme Court. Back in 2014, as the Obama administration started with the Clean Power Plan efforts, West Virginia and a coalition of states challenged that effort. Ultimately, in 2015, after we were unsuccessful in our attempt to get a stay in the D.C. Circuit, we went up all the way up to the U.S. Supreme Court, and in a historic stay, we stopped the Obama Clean Power Plan in its tracks. And I think that was a very strong message from the Supreme Court about the importance of clear statements. And so here we are now, back in 2022, and seems like deja vu again. We're back in a similar place. But I think we have optimism about the result we're going to get. Now, if you look, as time went by, after that 2016 decision, the Trump administration stepped up and they issued an ACE rule. We thought that that was consistent with the Clean Air Act authority. Notably, we've never said that the EPA lacks any authority to address climate change. We have a much different definition in terms of what's permissible under the Clean Air Act and the Major Questions Doctrine, as opposed to some of my colleagues on the other side. But of course, our Supreme Court case that will be heard on February 28th springs from the D.C. Circuit Court decision of January 19th of last year, where the D.C. Circuit had a very expansive view of federal agency power and arguably gave the EPA a virtually unlimited ability to decarbonize our nation, which is very limited limits. We took issue with that, and that's why we organized a coalition to go up to the U.S. Supreme Court. We asked for cert to be granted, and we were fortunate that it was, because I think, and we're hopeful, this court understands this really is about resolving the critical Major Questions Doctrine, and once and for all, giving clarity in terms of the role of the Clean Air Act and Congress in the regulation of greenhouse gases. Now, this debate about the size and scope of government has profound effects across our nation, and especially in West Virginia. It doesn't need to be echoed too much, but West Virginia is still very heavily dependent on some of the types of fuels that would be most impacted by the Biden administration and a number of their proposals. West Virginia still relies 86% on coal for fuel sources. It still relies on natural gas and oil. That's critically important. The number of jobs that are affected by this activity, significant in West Virginia and across the country. And of course, huge implications for consumers. The reordering of the power grid will have a profound effect on the price of energy, and that's deeply troubling. All of that's important, but what really matters, of course, is if you have something that's that fundamental, that's major, you have to make sure that Congress steps in. And Congress gets to make these major decisions of the day. When you have something with such significant political, social, or economic consequence, it's the role of Congress to provide that clear statement. And here's why. Everyone under our constitutional republic has the opportunity to participate in the legal process. You don't want the decision that has such profound consequences to be made by an unelected bureaucracy. That means New York, West Virginia, California, Texas. Everyone needs to have a role in the process. That's what we're trying to ensure happens in this case. If we didn't prevail, we're terribly concerned about what would happen with a lot of these federal agencies being able to issue broad regulations without that authority that's granted to them by Congress. So the implications are significant on a going forward basis. We're appreciative of the fact that the court has taken this case up because it's very timely. We know that the other side has raised questions of standing, but we're grateful that the court has already gotten past that issue. They've granted cert. We think that's critical. We also know that this represents a chance to finally stop the volleying that's gone back and forth with interpretations of the Clean Air Act. Section 111D has been richly debated over the course of the past 8 years or so. It's time to bring clarity to these interpretations and provide finality to the states that care deeply about their energy future and care about the rule of law. So I'm pleased to be here today. I know we're going to be able to get into some very interesting questions. Thank you.
Thank you so much, Attorney General Morrisey. Attorney General Rokita?
Thank you. Thank you, Patrick. Well, thank you, Ms. Wilkins, and thank you, Attorney General Morrisey. And good afternoon to everyone. I appreciate the introduction, and I appreciate you, Attorney General Morrisey, for your leadership on this issue and other environmental issues for the entire time you've been an Attorney General helping lead the way. Indiana and our office at the Indiana Attorney General's office is very proud to be helping on this case along with several other states. Our role includes helping with research, helping with briefing, helping with moot court practice next week, for example. And yes, it's true, Indiana mines a lot of coal. We, until recently, use a lot of coal. And just like Wayne Stengham, a new friend of mine, but with time I spent in North Dakota, I realized how even states so far apart like North Dakota and Indiana have so much in common, that being fossil fuels. But as Attorney General Morrisey says, this case is about so much more than just that. In fact, this could have implications on other state agencies that have nothing to do with the environment, depending on which way this court rules. So this is important in a number of larger ways, and most fundamentally, has been alluded to, if not directly said, is the individual's relationship to their government, particularly their federal government. And that's what I'd like to talk a little bit about today, having been a U.S. representative in addition to my current position. And frankly, when I made the decision to leave the private sector and run for Attorney General, I could not have known what a large percentage of my time would be by necessity spent fighting the unlawful effects of the federal government to run roughshod over Hoosiers' liberties. Like I said, I got one view of it from Congress, but now in this sense, it comes at a whole other deeper level. And again, the case we are reviewing today is just one example of that. It's not really about climate change, environmental impact, or the use of coal. More fundamentally, it's about defending the Constitution and insisting that federal agencies such as the EPA cannot assume authority that has not been granted them by a lawmaker and a body of lawmakers. Now, one doesn't need to be a constitutional scholar to understand this, or even a president using a phone and a pen. One, the separation of powers and its capacity to prevent government by authoritarian degree is at the root of this discussion. So, sometimes Congress gets a bad rap. I know that firsthand, and sometimes it's deserved. But today's case isn't about congressional approval ratings. It's about the balance of power, about checks and balances that must be respected. And by the way, individual congressmen get a 60% approval rating on average from those in their district. So the fact of the matter is, those that Congress people represent like their congressmen. And the reason that is because they are closest to the people by design from our founders. They are the ones in smaller districts with a smaller number of people in tight election cycles to be held accountable by their constituency. Even more so than senators, but still, senators at least represent states, which are made up of people. Who doesn't represent people? Unelected bureaucrats. And that's the issue here. The founders insisted that lawmaking be done by lawmakers who are held accountable by the people. So unauthorized power grabs by federal agencies must be stopped. The Supreme Court has just in recent months reinvigorated this idea that if a federal agency addresses a major question of vast economic importance, the text of a statute must clearly delegate that authority. We just saw that with regard to vaccines and OSHA. So from that perspective, I'm encouraged that this case is coming on the heels of such another important decision. This case is another critical opportunity to vindicate the principle that when a federal agency addresses an area traditionally left to state regulation, Congress better have been clear about delegating authority to do that as well. So there's the delegation of authority from Congress to a bureaucracy and also from a state to a bureaucracy, and we maintain that wasn't properly done by those who voted on the Section 111 of the Clean Air Act. So when a federal agency issues rules that will unilaterally reshape our entire country's electric grid with no limits, it seems to be an obvious red flag. And when a federal agency inserts itself into the state's areas of authority, like regulation of utilities and electricity generation, that's a red flag. Ultimately, perhaps a state victory in the Supreme Court in this case will inspire Congress actually to do its job in writing laws rather than shirking its responsibility and waiting to see what the executive branch does. And what I'm alluding to here, or mentioning here, is the result when Congress, the lawmakers, unconstitutionally delegate their powers. It's called the non-delegation doctrine, and I saw it firsthand in Congress. Whether it's because we are under a deadline to get something done and laws had to be written in back rooms, or whether transparency wasn't particularly wanted because of the reality of a situation, or what have you, laws were written too vaguely. Maybe Congress just wanted to be lazy for a term or a week or a month or whatever it was. And they left it up to the unelected members of an agency to fill in the blanks, to actually solve the problem. We maintain that's unconstitutional. That's a violation of the non-delegation doctrine. It's a violation of separation of powers. The lawmakers need to make the laws, the executive branch needs to enforce, execute the laws, and the judicial branch needs to interpret the laws, and it's quite as simple as that. So when I say this case is more than just about coal, it is. It's about, again, individuals' relationship and power and authority over their own government. We, the people, must stay in charge if this Constitution is to, and this Republic is to be maintained. So with that, I'm happy to take your questions. Again, thank you for the invitation to be here. And Attorney General Morrisey, thank you for your leadership on issues like this. Thank you.
Thank you so much, Attorney General Rikita. Very much appreciate it. Given what I think the media's current approval rating is, I can't really speak at all on the approval rating of Congress. So We'll just skip right that. But I did want to start just kind of talking a little bit back to the basics of the case that will be argued in front of the Supreme Court. I mean, I know that you did mention that this has to do with a balance between federal regulations, federal authority, who has the authority to make laws. But I'm wondering if you can sort of solidify for us the exact questions that are being asked in this case in terms of the Clean Air Act and the EPA.
Well, I think as many people know, there's been a very robust debate about the amount of authority that's in possession of EPA under Section 111D of the Clean Air Act. So there have been different interpretations for many, many years on that point. So
and what is Section 111D, just for those of us at here and at home who are not experts on the issue?
Section 111D is intended to provide a very limited amount of authority to create a best system of emission reduction, but to regulate particular sources. And in this case, we're talking about a greenhouse gas, because flowing from the Massachusetts v. EPA case, the EPA has viewed that they've had a charge to act in this area. So since that case, there's been a big debate about how you could carry that out. And so people have looked to this very little used statute under the Clean Air Act, which is designed to regulate sources. Think of a building, think of a coal-fired power plant. And one of the big disputes, by the way, that we're having with the other side is that we think that the nature of the authority is limited to regulating, particular sources, as opposed to going very far afield, having a tremendous impact on consumer issues, or regulating the owners and operators of the coal-fired power plants, forcing them to cross-subsidize renewable forms of energy. So all of those issues are up before the court now, but it's really under the framework as to what authority the EPA has generally to regulate greenhouse gases. We've acknowledged that there is this narrow area to regulate specific sources, but to suggest that the EPA has the ability to completely reorder the power grid and to go so far afield into people's lives, and Congress never provided a clear statement to that to us is a very big stretch. That's the essence of the question that's asked for the court.
And Attorney General Rokita, I don't know if you had anything you want to add to that.
No, just real quickly and simply to say, the EPA thinks it has the ability to decide, who regulates, when it regulates, how it regulates an entire industry. This one particularly, fossil fuel-fired power plants that create electricity. And if you allow that thinking to rule the day, then where does it stop? You can now decide that any industry that generates too much of what you don't like can be stopped and shut down, whatever that industry is. Flower shops, whatever. It could go on forever, outside just the actual generation of electricity from the point. So it's a creep.
And so going from there then, I mean, what would you say, because you did mention that, there is a role for the EPA, that the EPA does have some authority here. What role then would you want to see the EPA be limited to in a favorable ruling for yourself?
Absolutely. Well, first of all, I think that the ACE rule represents that. If you go back in time, when you talk about regulating the efficiency of the power plants, and that's certainly permissible.
And the ACE rule is the
ACE rule was the one that was issued by President Trump. That's what fell at the DC Circuit January of 2021. So there are narrow areas, but to be clear, this is an area that's constantly evolving. And you need look no further than Congress and the debates that are occurring right now about the very many tax incentives and the provisions pertaining to climate change to show that this is an ongoing discussion that Congress is having. So we want to be really clear that Congress makes those choices, that it's not up to the EPA unelected bureaucrats to step in, when to us it's very clear that that authority is constrained.
You've mentioned Congress a couple times. I happen to cover Congress, and Attorney General Rokita, I definitely want to hear from you on this one. Congress isn't really getting a lot done these days, and they're getting even less done on climate. I mean, Biden, Trump, pick whichever president you like, they are democratically elected by the American people. Why don't they have the power to address some of these issues, particularly climate change, which we're getting more and more consensus on is a major issue that does need to be addressed and is impacting Americans.
So first of all, I think you hit it on the head. It represents a major question of the day. And we can all reach agreement on that with respect to climate change, that there's going to be a robust debate from both sides of the issue. But that's a determination for Congress to make as to what type of authority it seeks to delegate to the agencies. And so a lot of times people say, well, we don't know whether Congress will be able to take action. The question of whether to take action or not to take action, or the scope of that action, that's all left to Congress to make the decision. And that's where the people of the United States get to weigh in. Once again, whether they're in Indiana or Texas, New York, West Virginia, all across the board, they then express their voice to the people's representatives who decide what their priorities are, and then Congress makes the call.
Mm-hmm. And I'm sorry, I keep wanting to call you Congressman Rokita. I apologize, because that's going to happen
I
at
thought
some
you
point.
liked
I'm
me.
going to slip. But I also wanted to sort of get your sense on this. I mean, you saw Trump go ahead and make a number of regulations. You've seen Bush make a number of regulations. This is certainly not a partisan thing for a president to make and carry out regulations. Why doesn't the president?
In President Trump's
have that
case, it was,
authority?
I look at it as more as a regulation to deregulate.
enough.
You know, so, and that's in line with what I was saying at the podium. Because it is the lawmaker's purview to do things like that. And look, hey, we're only, the Senate is tied. I think the House only has, what, 4 more Democrats than Republicans, or it's close.
Yeah, it's a 5-seat majority.
Yeah, so I mean, that they're not getting anything done, you know, it shouldn't be surprising. And then, of course, our founders and many others prefer that the lawmakers not get a lot done, quote unquote, not to ramrod things through, to have deliberate debate and thinking through some of these things before we impose a regulation, a law on the people. And that's what Attorney General Morrisey, that's how I take his comments. So I'm okay that, you know, that debate goes on and that they may not be getting done things in terms of scoring laws, right? But my problem, where I take your question, is that they're not even talking about it. They're not debating it. They're not doing those things I think that they're supposed to be doing under the Constitution. A regular order is the term. You're familiar with that. And that's the idea that we're going to go through a regular process in Congress to evaluate, debate, construct, and ultimately pass or not a law. And that's the thing that's not being done in Congress right now, and that leads to an increase in power for bureaucracies because it leaves so many things unsettled in the statute, in the law, and open for a bureaucrat to go and run with it. And that allows presidents then of what other side to go and do the things that you just mentioned, which isn't healthy.
And can I ask, I mean, since you have spent so many years in Congress, do you see any ability to move forward? When does Congress move forward? What are the circumstances when they move actually forward on legislation addressing climate change and greenhouse gases? Well,
you know, a lot of it should be left to the states, number one, and a lot of it should be left. I think when the people finally really demand it. I mean, you could say here, well, we all understand we're having some consensus on climate change. Not from where I sit in Indiana. There's a huge and healthy debate. Yes, the climate changes. How much humans have to do with it, a completely different question.
I want to add to this point, though. I think it's really important because regardless of what happens in Congress, there's never an excuse for an unelected bureaucracy and an agency to seize power that's otherwise intended for the people, for Congress, or for the states. And that's why if you go back through the case law, people acknowledge that there have to be clear statements by Congress about the nature of the authority that's delegated to the agency. There have to be clear statements when you're trying to intrude on the state lane. For instance, if we're talking about redoing how electricity is managed or sold across the country, you're not only involving, they would want to involve the EPA, but you have FERC, you have the role of the states, the public utilities across the board. So it seems clear to us that there has been no clear statement. We all acknowledge it's a major question, right? If anything's a major question of the day, it's got to be climate change, right? So if we acknowledge that, then the question has to be, how has Congress spoken to this issue? And even if they're fighting back and forth, or they decide, as they have, to focus a lot of their energies on tax incentives or other programs, that's still solely within the purview of Congress until they delegate to that agency properly.
Got it. We also are having a couple questions come in, I think, from people who are very well versed on this issue, more so than me, so thank you for sending those. Ella Nielsen at CNN says, Attorney General Morrisey, she wants you to respond to the fact that power companies are siding with the EPA in this case. In their amicus brief, the Edison Electric Institute said stripping the EPA of its regulatory authority, quote, would be chaos for their member companies and open them up to constant litigation. Do you share that concern?
No, to be honest, I think that brief and some of the approaches, the distracting side, has really misread what this case is all about. There are a lot of people who have postured that this is an attempt to override one case or another. I think that brief goes in that direction. But in fact, this, once again, is about who gets to make the decision. It's Congress. There's no secret agenda, if you will, that's being articulated. This is about who makes the decision. And so we know that everyone has different economic incentives as to why they make their decisions. I'm not going to go into all of those right now, but I can say that people should look at the briefs. People should look at the fact that we're talking about the wrestling match between the legislative branch of our federal government and the executive branch of our federal government, and how we have that balance of power between the two. People shouldn't read it into talking about the merits of climate change. We've been very sensitive and careful that there's an ongoing debate about that. That's not what this case is all about. It's not, as some suggest, about overruling Massachusetts v. EPA. And that was the premise of the EEI brief. That's not the case. So they've missed the mark because they're all running away from the basic fact that if you have a separation of powers question, you have to look to what Congress delegates specifically, how clear are they on the authority to the agency. People are trying to distract with a lot of issues. That's what the case is all about.
And we also have a question from Jennifer Dulhey with Bloomberg. Got to read it, of course, the company. She appreciates your observation about this being a timely chance to end the volleying over the Clean Air Act regulations of power plant greenhouse gas emissions. But more directly, she wants to ask how you respond to the argument that this case was improvidently granted because there's no case or controversy given that the EPA is abandoning both the Clean Power Plant and the ACE rule.
Well, look, I can quickly address this. We have a great deal of respect for the Supreme Court. They granted cert based upon all of the facts and the injury, which I don't think people would argue about at the time. We think that still applies right now. There are cognizable harms. There's a very meaningful risk that this administration is going to step forward and to put back in place certain elements of the old Clean Power Plan. We think the harm has gone going. We absolutely meet the definition of standing. It's a live case. And just the fact that you mentioned, this has been volleying back and forth, this is an agency that could repeat past decisions. And so I think the case law is very clear that once we've passed the test that we have, this is certainly ripe and appropriate for the court to act on. There aren't going to be any factual disputes that come up. Nothing's going to change. And rather than have this go on for 4 or 5 years into the future, the state of the law is teed up for the court right now to decide.
I just want to see if we could dig in a little bit more. I mean, if the Supreme Court does rule unfavorably to you in this case, what are the specific consequences going to be? Because I feel like we can talk in vague terms about who has the power in Washington, but I'm wondering, to get into the very specifics here, what would that mean?
Well, two things. One, and I don't know if you want to jump in and weigh in.
Just to say, again, not only who regulates, but how and when, and where do you stop? Now, I made my flower shop example earlier as an extreme, but if you can jump from regulating a coal-fired or fossil fuel power plant to any industry, this case is decided the wrong way, that's what could happen. Even to your house, think about that. Maybe your house is determined by a bureaucrat to be an emitter, and it's emitting too much of carbon dioxide. Again, there's no place for it to stop. Patrick?
Think about the implications, not only from an EPA perspective, in terms of regulating sources. First of all, if you can go so far afield and you can start to reorder the power grid, let's talk about the implications there. A lot of experts have estimated that as a result of some of the plans and the proposals that are out there, the price of electricity would skyrocket. That's a very significant impact of what would happen. But I think it even goes beyond that. And this is why I keep going back to the who makes the decision question. That's what this is all about. If this case is allowed to go forward and the DC Circuit's broad view of federal agency power holds, that you can have a federal agency with the most minimal grant of authority in this area be able to unilaterally decarbonize and go really far afield from items that have ever historically been regulated under the Clean Air Act, that's significant because that's something also that can be replicated across the board. We know sometimes that when Congress struggles, that executives of both parties step up and they try to regulate. So I think this case is really important because you get to set better guideposts in terms of how federal agencies are going to act based upon a principle. When you have a major question of the day, you better get it right, both for purposes of not intruding on congressional authority, but on the state's authority too.
We have another question here from David, and David, I apologize, David Doinger, I think, from the Climate and Clean Energy Program. He asked, what would the statutory language have to say to meet your criterion of a clear statement authorizing EPA to regulate carbon dioxide emissions from power plants? Attorney General Rakita, I'm going to throw this one to you since you've got the experience.
Sure, that's fine. I mean, again, that's not what this case is about. It's not the standard we have to meet. But play devil's advocate along with the question, I'd say if Congress, right, the WHO, decided that, you know what, no, we do think and we do mean for the EPA to create schemes so that they can manage and restrict systems, where systems means the entire industry. I mean, it'd have to be that specific in order to legally, constitutionally do what the EPA right now is trying to do.
I would also add that whenever you're looking at delegating power, courts look to the limitations that are put in place in terms of the Congress made a thoughtful decision about what was delegated. And so that's what people look at. When you have a court decision which has virtually no limits, and that's what's happened in that DC Circuit Court decision. It's so broad in its interpretation, that's clearly not right. So we're not here to do the opposition's work in terms of exactly how to write the statute, but I will say this. After we win the case, I'd be the first one to step in and we could provide back and forth, at least on West Virginia's perspective, about how some of these issues should be dealt with, but that'll be proper after we get through this case.
I've also gotten a couple questions, and I think we briefly touched on this before, but I'm just sort of going to go back a little further into it. There's currently no greenhouse gas rule for power plants on the books yet from the Biden administration. What do you hope to accomplish here with this weigh-in with the Supreme Court? Is this question premature at all?
No, it's not premature because, once again, you always have to be mindful of the axe over the head, and when an agency can reinitiate immediately, and this has been an issue that's bounced back and forth for some time, the threat is very real, it's imminent right now, and so it's easy for one side to say, well, we haven't gone forward and locked down the mandate, and therefore, you don't have standing to act. That's not how our constitutional system operates, and we've met the test of standing, and this is a live case right now. We think it's important to get clarity on this major question of the day, to the extent that going forward, whether it's the Biden administration or a future administration, it hopes to have some additional guideposts in terms of when these agencies can act and when they cannot act, and that might help Congress do its job just a little bit better.
And Attorney General Rakita, I didn't know if you had anything that you wanted to add.
No, you covered it. I mean, look, I think the Supreme Court did the right thing. We had this volley that we've talked about going back and forth, and they've said, finally, let's look at both sides of this volley and take up this case at this time.
Sure, sure. And we also have another question from Coral Davenport with the New York Times. Would you argue that the EPA does not have the authority to regulate greenhouse gases at all? Or would you argue or expect for SCOTUS to repeal Mass versus EPA or the endangerment finding?
Well, couple things.
Yeah.
First of all, we've said that we have conceded that they do have a limited authority to regulate. So we've said that repeatedly.
At the site or inside the fence.
And so
Correct.
would that be like specifically like there is a site that exists in Indianapolis and at that particular site they can require certain
they have
things?
to live up to the statute's limits, which talk about regulating a source. So we've always acknowledged that. I don't think that's a debate that goes back and forth. And I've also mentioned repeatedly when folks try to make this, is this about overturning Mass v. EPA? That's not what's being considered in this case. We've put all of our energy, and I'm going to go back to the message, on a basic premise. If there's a major question of the day, regardless of where you stand on the issue of climate change, on the vaccine mandate, whatever the issue may be, don't you think that Congress needs to provide a clear statement to that agency before it acts? That's what the case is all about. It's not about some of these other cases that folks think that we're trying to overthrow.
Attorney General Akita, I didn't know. if
Yeah,
you-
just to take that one step further, not saying that that this is not part of the case or anything like that, but as my opening remarks suggested, we as individuals in a free republic should expect Congress to write the law with enough specificity so that the agency doesn't have to do any thinking about it or do any interpretation about it. And I have a specific story about that, if you don't mind, from when I was in Congress. I was invited by the late Antonin Scalia to dinner once, and you know, when an Italian asks you to go to dinner at the back room of an Italian restaurant, you know, I usually don't go. You know, it's just the way I was brought up, I guess. But I went. Perhaps it was my inner diversity, equity, and inclusion officer telling me I was stereotyping. I don't know, but I went. And it was right on the heels of the decision about Obamacare, where the Supreme Court decided it was a tax and therefore perfectly fine. And here I was, a new congressman, and campaigned on that issue and pledged to do everything I can to get rid of Obamacare, and I stuck to that and still do. But when I had the opportunity to ask the Supreme Court justice, hey, you know, I need a little bit of help here. At the time, you know, President Obama was in office, Harry Reid was, and the Democrats were in charge of the Senate. We just had the House. Need some help. And he gave me the hand a bit and said, hey, you're asking the Supreme Court to bail you out here, and it's really the lawmakers who are supposed to write the laws. And you all are not writing your laws with enough specificity, so as a result, you cede all this authority to unelected officials, and you make them lawmakers. And that is inherently and completely wrong in terms of our Constitution. And it's something I always took to heart, and with another speech another time, we could give you some examples of that, but that's the point I'm trying to make here. Lawmakers have got to do their job on major questions so that the bureaucracies are agencies that simply carry out as part of the executive branch what that law is.
Given that though, well,
I was just going to add one other quick point. When you look at this case, this should be the ultimate bipartisan case. And here's why. If you think about it, this is not about the merits of climate change one way or the other. It's ultimately about, should we make sure that the balance between the legislative branch and the executive branch is consistent with how the Constitution laid it out. There are going to be Republicans that overreach in terms of their authorities. There are going to be Democrats that overreach. Let's not change the rules to empower these bureaucrats to unearth broad new positions on the American economy that let them affect all the consumers. Let's allow our elected representatives to do that.
in that regard, I do have another question from Jennifer with Bloomberg that kind of speaks to this very directly. She said, playing devil's advocate, did the founders really want Congress to be mirrored in the minutia of setting emissions caps and regulating electricity markets? Isn't that more appropriate to be the role of expert agencies?
Only when specifically delegated to do that task and nothing more.
And furthermore, agencies don't have the ability to just seize power for themselves. Agencies are ultimately a creature, they're created by Congress, and they need to act consistent with the power that's provided to them. You don't want to have a roving agency making decisions about who's going to be making the decisions and potentially overriding state action. The area with respect to electricity sales and regulation, there's so much power that right now is in the possession of the states. When you get one federal agency that starts to run roughshod over that area, it has very significant downstream impacts that everyone feels.
So, and I'm Attorney General Akita, I'm going to toss this one back to you again, just because of your experience at Congress and at the federal level writing these laws. Why aren't these laws then more specific? Especially when you have many of these laws that are, they are thousands of pages long, of very minutiae text, put together by some very smart people who clearly know what they're talking about to read them. But why do they not cover all of these little details? And how would you suggest that Congress begins writing more comprehensive?
That's the hard work that Justice Scalia was talking about and that I mentioned at the podium. And that's why you shouldn't judge Congress on the number of laws it passes. Because you can pass 1,000 laws that are absolutely terrible in terms of their specificity on whatever issue. And that's the work of Congress in a deliberative thinking body. And it's I love my colleagues. I oftentimes thought often in the room when I was with them that I was the weakest link. I mean, they're phenomenal human beings and individuals in those bodies. Something happens when we all get together in a system. But it's that hard work that I don't think is being done. And I think the best test of whether or not you wrote a law with enough specificity is if the agency, when it goes to do its rulemaking associated with a given piece of legislation, and by the way, it's the lawmaker who has to even cede the authority to make rules. So you could do negotiated rulemaking, you could hardly allow any rulemaking, if at all. In your law. And if an agency, like happened with one of my bills, comes back and says, we don't even have to do a public comment on these proposed rules. And that scared me initially. And they said, and when you asked why, or later down in a couple paragraphs, they said, we found the legislation was so specific that we are simply repeating the legislation as the rule. So it can be done.
And Attorney General Morrisey, I didn't know if you had anything to add to that?
Well, one point that I've always been thinking has been lost in this debate is that a lot of times people have tried to enter into the climate change discussion and talk about the urgency, the importance of federal agencies to act, but ultimately, whatever happens, you want to have the confidence of the American people that their elected representatives stood up and made a decision. It's not supposed to be that easy to just pass laws on the most controversial topics of the day,
right.
But there are other avenues available for citizens or activists, regardless of your position. Private parties step up, they take action, you see that. You see states step up and take action. So I think the system is working as intended to make sure that it's respecting the division of powers between the states and the federal government, and between the legislative and the executive branch.
Speaking when it comes to trust, I know that there have been some concerns that have been raised from different quarters about the ability to trust the Supreme Court and the politicization of the Supreme Court in recent years. And I wanted to see if you guys could just sort of weigh in a little bit. I mean, do you think the Supreme Court is going to be influenced at all by politics here, given how controversial the issue of climate change can sometimes be?
I think that I'm hopeful that the Supreme Court is going to look at the cases and the experience we have with the major questions doctrine, and you need look no further than the OSHA rule that came out recently. Mm-hmm. I think that we're very hopeful that the court will look at it and say, this is a major questions case, and we're going to decide it the way we have a number of other major questions cases in the past, and that we'll be able to get even greater clarity in terms of how the administrative state will operate into the future. And the American public should have great confidence in that, because there's an analytic consistency to how this Supreme Court is approaching the separation of powers between the legislature and between the executive branch.
And Attorney General Akita, I wanted to...
Yeah, just to add, not much to add to that, except to say that it seems like every issue these days is political. And you can't expect judges to avoid that. They live their lives. They're allowed to bring their experiences to the bench. And I certainly respect that. What we hope and what we also expect, though, is that they're able, we put them there in one form or another, and this is judges at all different levels, to have the discernment to separate their own personal politics from the decision and to decide the issue before them based on the Constitution. And what also our expectation is that the way they look at the Constitution is not that of a living document, but that of words of wisdom that have transcended time and have made us an exceptional nation.
Well, we are getting towards the end of the hour, and before we wrap the discussion today, I do want to take a moment to thank the Headliners Co-team leaders, Donima Linline-Leisure and Lori Russo, Headliners team member who organized today's event, Frank Massino, thank you so much. The club membership director, Kate Helster, and club executive director, Bill McCarron. I would also like to thank both of you so much for being with us today. I've got a final question left in a minute, but before I do, I am going to present you with the gift that we give everyone at the Press Club, our official Press Club mug. I hope you use it to drink lots of delicious coffee or tea.
Now I can retire from politics. Took me this long to get here.
I also wanted to give everyone who's watching a quick reminder that you are more than welcome to join us on Wednesday, February 24th at 11 a.m. for our upcoming National Press Club's headliner event with the American Medical Association President, Dr. Gerald E. Harmon, who will address the state of COVID-19 pandemic as it enters its third year. I don't like that sentence, but there you go. And I did want to just sort of close out by asking, I feel like you guys have really repeatedly made the case that this isn't about climate change, that this is about the separation of federal power and who in the federal government gets to make the power. I did, at least for 1 minute, want to sort of just talk with you both as top-ranking officials in the Republican Party for your respective states and really nationally. What do you think the Republican Party's outlook does need to be when it comes to issues of climate change? Because I feel like you've seen Republican leader in the House, Kevin McCarthy, he's created a focus group on this. You've seen Senate Minority Leader Mitch McConnell say that it is human-based climate change occurring. Where do you sort of see your party going on this particular issue?
Well, I'll start out and just say that the most important thing we could do is to be inclusive of different perspectives, to debate these issues in an open forum. So I'm saying that coming from West Virginia. And West Virginia is a proud state with a rich heritage in coal, oil, gas, manufacturing jobs. But I'd be the first to acknowledge that when you have to make decisions on issues of the day, they need to be made with everyone at the table, with everyone, even if you don't agree with all those perspectives. That's part of it. So process sometimes drives the substantive result. And maybe because I'm in the Attorney General's chair right now, I would say that's the biggest message I can have. Have the right process, and regardless of who's in the White House, get the darn process right and don't federally overreach on the states or on private parties. That should be part of any agenda.
And as they say in Congress, I associate with the gentleman from West Virginia. I think that's exactly right. I completely concur. Also add is that we have to do this inclusively, driven by data.
That's right.
Driven by data that's accurate and not emotion. And that's the harder thing. It's much easier to win over a jury, for example, based on emotion than it is fact. But we, I think, as diverse as our nation is and the different policies and viewpoints and ideologies that we have, if we can be driven by data on this before we wreck people's lives in the interest of trying to save people, that we do this very carefully, inclusively, and soberly.
I couldn't agree more, and I'll conclude with one point. West Virginia suffered very greatly from a lot of the decisions in the past, even when some of the rules weren't finalized. It's important that you get it right. This presents an opportunity to truly get it right.
Well, thank you, gentlemen, both so much for being with us today. Thank you, and we'll definitely be looking forward to February 28th and to the Supreme Court arguments and then the subsequent decision. Definitely will, as they said, it's a monster of a case, and we'll be looking forward to following it.
Thank you so much.
Thank you so much for being here today.
Thank you.